How about the discrimination point?
In the lower court, we argued that this was not discrimination. At least that's my understanding, and also that. But beyond that, the position here that this is that. I don't know if one calls it justification or it's not discrimination. That you can look at it either way. That discrimination is a conclusion that encompasses whatever justifications may be offered for the policy, or that it's not discrimination in the first place. If the question just focused on whether there were distinctions, then the statute would use distinctions, but it uses the word discrimination, which I think we would view as being a conclusion, and read into that should be, particularly on something like consular venue, the ability of the United States to take into account nationality considerations. As we point out in our brief, when Congress enacted this provision in 1965, it had long been the policy of the United States before then and since then, for example, to adopt special procedures for security purposes for aliens from particular nations, from communist bloc countries for a while. And as there's a declaration cited at page 17 of the petition that describes that history and describes what was before Congress in 1965. I think that goes to actually 2 points, that 1152A1, the non-discrimination provision, didn't apply to the applications for visas in the first place, but even if it did, Congress could not have meant to absolutely prohibit, irrespective of the justification, the taking into account of nationality in the processing, in the procedures for the filing, the venue, and the review of visa applications. That the non-discrimination provision was really intended from the outset to apply only to the allocation of visas.
Let me ask you one more question. The government